At this point, I'd like to shift to our CLE presentation. You know, Mr. Rogel has been a good friend. We've talked a number of times. He's been in practice about 30 years, 40 years? 40 years. 30 years in private practice. The past 10, he's been in charge of the legal department at Professional National Title Network. He and others have grown increasingly concerned about what's going on in the area of bifurcation. And this Senate Bill 65, which has gone through a number of iterations, and he'll be talking about the most recent version, and you have your handout, is what he's come to talk to us about today. So without further ado, Joseph Rogel.
Hello. Well, thanks, Ralph, and thanks to the IRELA board and the members for having me here to speak with you about this issue that we see as a dangerous trend, or the beginning of a trend anyway, which we call bifurcation. In some places it's called split closings, but it's the situation, very briefly, it's a situation where you have one title company that issues the owner's policy and the owner's commitment in a transaction. You got a different title company that does the mortgage policy and does the closing. So you've got two different title agencies handling the same closing. We're concerned about this now in particular because over the last year or so, about a year ago or so, we saw an increase in complaints from our subscribing member attorneys about this practice. Some of our lawyers have called us and said, hey, I've got somebody on the buy side who wants to use a different title company. What do I do? How does this work? So because of several reasons, we see this as a problem for consumers and also a danger to the Illinois residential real property conveyancing bar. So just to describe the problem a little bit and talk about some of the practical consequences of this sort of a practice, we can start with the proposition that anybody who pays for a title policy in a transaction has the right to choose that title company. So typically, historically in Illinois, the seller pays for the buyer's owner's policy, and so of course the seller's side of the transaction chooses the owner's policy. The buyer also has the right under the law, because the buyer is paying for the mortgage policy, to choose the title company that will issue that mortgage policy. Historically, though, in Illinois, we have transaction control on the seller side of the deal, and that's because when the seller chooses a title company to issue the owner's policy, and I'm stating the obvious here, but just for the record, that title company normally can offer the mortgage policy to the borrower at a deep discount as a simultaneously issued policy. Because that title company has already done all of the heavy lifting for the owner's policy, the search, the commitment, and everything, they can offer a discount to the buyer on the mortgage policy. And of course, economically, normally the buyer wouldn't choose a different title company for the mortgage policy because it would tend to be much more expensive. So the result, as I said, is that the transaction control, we call it transaction control, is on the sell side of the deal. So as a lawyer for a seller in a transaction, typically you'll find that you're going to be the one who chooses the title company. Your title agency, whoever you use, will be the one that does the owner's policy, mortgage policy, and acts as the escrow agent in the transaction. And in the past, there have been a few, the problem of bifurcated closings has been sort of isolated and rare. I don't know how many of you may have experienced this phenomenon yourselves. I know that when I was practicing, I can only recall 2 times this happening, and the first time it was because actually both times it was because somebody on the buyer's side had a friend who was a salesperson or in some way affiliated with a title company, and they insisted on using that title company. And I remember the first time this was presented to me back in the day, I said, yeah, that's fine. Well, it's no problem, until I got into the deal. And then, of course, it was a huge problem logistically. I think anybody that's ever been through it knows just how badly this sort of thing sucks. You don't know who's doing what. You got to go to 2 closings. So the second time that it happened, I think for the same reason, somebody on the buy side, had a relative with the title company. I just told the buyer's attorney, go ahead and you do the deal. Let's not go through this. I've been through this. You do the deal. So that, I'm sorry.
What I usually do if that happens is I just reduce the price to whatever the other guy can get.
Yeah, that's, sure, that's a
Joe,
solution.
if you would, since we're recording, if you could try to repeat the question, it'd be great.
I'm sorry. The questioner said that what she usually does in this sort of situation was to simply match the price, and that is a solution that I'll mention in a few minutes when we get into it a little bit. The 2 experiences that I had really didn't have anything to do with price so much, though. They just wanted to use, they wanted the business to go to somebody that they knew. So doing that would not have helped in those situations. But that might be a solution for the trend that we feel that we're experiencing now. As I said, we think that the problem is more serious now because there is a trend of realtors and lenders acquiring interests in title companies and becoming affiliated with title companies. And the lenders and the realtors usually have access to the buyer before the buyer retains an attorney and seeks the advice of counsel on contract issues, including whether to bifurcate the transaction. So the fact that the mortgage policy is less expensive when the seller does both sides of the deal, as I said, means that the transaction control remains on the sell side of the transaction. What we've experienced this past spring, or I should say in spring of 2016, was several transactions where the lender offered to the borrower, to the buyer, a very deep discount for doing the mortgage policy. And of course, the borrower wants to take advantage of this deal. And so we had the lawyers calling us to find out what do we do. This threatens transaction control, because once transaction control shifts away from the sell side, I think that, as we know as real estate lawyers, it pretty much spells the end of our residential real estate practice, because everybody knows that lawyers need to have the additional revenue in real estate transactions, residential real estate transactions, that providing core title services provide. If we can't do the core title services and provide title services to our clients and the parties in the transaction, there just isn't enough revenue to sustain a viable practice. We can't really make a living. I wanted to mention for a second here an example of how things have changed a little bit, and I know I'm preaching to the saved here, but we've already seen a bit of shifting in the transaction, in control of the transaction, simply by reason of the way that the buy side of the transaction has been loaded up with fees over the past couple of decades. And it used to be where the seller side, the sell side had control because of the fact that that's where the money was. That was paying the money. Just for an example here, I've got an invoice from a title company for it looks like a very small transaction. This came across my desk a couple of months ago. This is for a single family condo in Oak Lawn, which is a middle class suburb on the southwest corner of the city. But the purchase price on this condominium is $43,700. The seller's title charge is $1,700, and the buyer's charge for title is $500. When we add in all of the additional fees for endorsements and handling fees and email fees and all of that sort of thing, we end up with, and of course recording fees, we end up with the sell side paying an additional $244 for a total of $1,944, and the buy side is up around $3,000. So the total charges on the transaction are about $5,000, which you can see it exceeds even 10% of the purchase price in this particular transaction. So we've got a situation now where title companies who are coming into the market and who are affiliating with lenders and realtors have an opportunity to offer discounts on a lot of these junk fees in order to wrest transaction control from the sell side. And we think that's dangerous. The problems that this causes, I break down into several categories. There are the logistical problems, which I touched on a minute ago. There are some serious legal problems. There are the harm that is likely to be caused to the real estate bar, as well as the harm that consumers will suffer if this becomes prevalent. And I should also say that I think that if bifurcation becomes prevalent, if this trend continues, and we'll see in a couple of months, matter of fact, we just had a new bifurcated transaction just 2 weeks ago come in. So I think that the bifurcation phenomenon is just going to be a phase on the way to moving transaction control from the sell side to the buy side. Once transaction control moves to the buy side, there's no need for bifurcation anymore and all of its inconveniences and problems. It's just that the sell side, the lawyer for the seller, won't be involved in this anymore. So first of all, the problems that arise are logistical, first of all, and these are probably the least serious of the consequences, although they are pretty serious. But in effect, you've got a split closing. You're going to 2 closings to handle that sale transaction. The seller executes the deed and the other seller's conveyance documents at the closing at the owner's policy title agency, usually delivers it to their attorney to be delivered to the buyers at the time that the deal is funded at the second closing. The seller's title company will certainly not want to commit to issue an owner's policy until they know that the transaction has been funded, consideration has been paid, and some owners' title agencies, I should say sellers' title agencies that issue the owner's policies, want to be in control of recording the deed so that they know that that conveyance has been recorded. In the second closing, the buyers execute the mortgage and loan documents. That takes place at the lender's title agency. And this title agency will, number one, want to be sure that the deed gets recorded before the mortgage is recorded, of course. And sometimes that title agency wants to be in charge of recording the transaction. So it creates a situation where the lines of responsibility are confused, and the cautious resolution of these issues always results in inconvenience for the parties and the attorneys. Maybe not so much for the parties, because a lot of times these days, we know that our clients can avoid coming to the closings if we can get them into the office to sign documents ahead of time. But certainly inconvenience for the lawyers and additional expense for the parties because you have to attend 2 closings. The lawyer is still responsible for making sure that the title is conveyed and that the sellers get their check for the proceeds and that the buyer gets their keys for the residence. One situation last spring, we had a situation where funding of the purchase at the second closing was delayed because of this confusion, which created a problem with the seller who had been scheduled to close their purchase after their sale closed. And so, as we all know, these back-to-back closings are very common. They're not uncommon at all, and timing is everything. If you get a delay in funding, it can cause serious problems on all sides of the transaction, including the possibility that the seller might be in breach of their contract to purchase their new residence. So in addition to those practical or logistical problems or problems of inconvenience, I think the next level of serious problems are the legal problems that can result from this sort of an arrangement. As we all know, the contract forms that are generally in use, the multi-board 6.0, all provide 6.1. Sorry, I knew there was another one.
Yes.
But all of the iterations of the multi-board and almost all of and I believe every form contract that I've seen provides that in the event that a title exception is raised on a title commitment, on the owner's title commitment, and the seller can arrange to have that exception waived or insured over or an endorsement or something, if the seller can arrange for title insurance to cover that exception, the title is deemed to be clean, thereby triggering the buyer's obligation to go ahead and perform. And in two of the situations we had this past year, we had a problem. One was on a deal of ours. One was on a deal where our member attorney had put the title through a different title agency, which our members do. It's not an exclusive club. But the situation in one was our commitment raised an old mortgage that we were willing to waive. Under our underwriters' underwriting standards, we had the okay to go ahead and waive that thing. The problem was that on the lender's title company would not waive that exception. And so they wanted more information. They wanted to see if there were any old HUDs or other evidence that might indicate a payoff of that old mortgage. And of course, the seller in a situation like this, of course, they want to get the deal closed, although sometimes they don't. Sometimes they want to get out of the deal. But the seller is under no obligation to jump through any hoops to provide title clearance for the buyer's title company, because they've performed under the contract, they've cleared the title for the owner's policy, and the buyer has an obligation to perform. In this particular case, there was a threat to forfeit earnest money. I think the closing got delayed. I'm pretty sure it closed anyway. You know, one good thing about all this is that when you have a buyer who wants to buy and a seller who wants to sell, and they've agreed on the price and they've agreed on everything, they want to do the deal. So in most cases, these things get worked out. I mean, I don't know that any of the problems that we've experienced recently have resulted in any sort of litigation. But the problems are there, and they're serious. Same thing goes for old judgments. I think the second case we had was a judgment that I could be wrong about that. Might have been a mechanics lien, but whatever it was, the difference. We all know that different title companies, different title agencies, underwriters have different underwriting standards. And I don't know about you, but I've been at deals where, you know, I have a problem getting the title company to waive something for me, and the attorney on the other side of the table says, oh, well, my title company will waive that. No problem. Let's move the deal there. So it's very clear that title companies have different underwriting standards, and some are willing to underwrite on I mean, a lot of it comes down to just what you're willing to do to get the deal done. A lot of it has to do with the relationship that you have with the people at the title company for, you know, allowing you, you know, a personal relationship goes a long way when an attorney can vouch for, you know, the activities of the seller in convincing somebody to take a chance and go ahead and waive something in order to get the deal done. And another thought that occurs to me, with regard to this bifurcation issue is that it really isn't all about who gets the money, who gets the revenues. I mean, it is because as I said, lawyers representing sellers need to have this additional revenue from core title service in order to have a sustainable practice. But it also has to do with control. I want to be the one, when I represent a seller, I want to be the one that's in control of getting the title work done. I don't want to have to bring, back when I first started, and we used to have to walk over to Chicago Title with a pile of stuff to get waivers and stuff like that, and I'd always go in there just hoping I had everything right in order to get the waiver. These days, when we do the title work for ourselves, according to the underwriter's published standards, we have control. We know what's going on that sell side. We know what we might need to do in order to get something waived, and that's a very important part of it. When you don't have that control, it's difficult to represent your client. Then you have to go to the client and say, look, I'll try and get this waived, but I don't know what they're going to tell me. So that's a big part of it. It really isn't all about revenues. Control of the transaction is important as well. We had another situation where this wasn't one of our deals, where the seller's title company for the first closing refused to waive any payoff exceptions, okay, because they weren't handling the money, and so they didn't want to waive the seller's mortgage because they weren't doing the payoff. They also, I think, in that same transaction, the seller's title company was reluctant to issue the gap coverage because they didn't have control over the recording of the documents. So obviously that was a risk that was the risk of the gap was a risk that was outside of their control and one that they didn't want to undertake. I have heard of situations where there's confusion about who is to issue the CPLs in the transaction, but I think it's pretty clear that the company that does the actual escrow service would be the one that issues the CPLs to the party.
Joe, what if there's two underwriters involved?
If there what?
If there are two underwriters involved?
Okay, the question is if there are two underwriters involved. Are you talking about for the CPL? Well, I still think that the company closing the transaction would issue certainly the lender's CPL, but since they're handling the money, I would think that they would issue all of the CPLs. Do you have a different idea?
Yes, only because the CPL would be tied to the other underwriter's policy.
Correct. Good point. Very good point. Excellent point. Phil just pointed something out to me, and I'm going to make a note of that. I'm going to say it tomorrow as if it was my idea. What Phil said was there really is a legal issue, a technical one that maybe nobody would think of, but a smart guy like him. But the CPLs are tied to the issuance of the policy. So how does the issuer of the owner's policy issue a CPL when they didn't handle the money? Am I stating it? Good point. I hope that doesn't come up in actual practice because we won't know what to do.
It will come up when there's a claim because then they're going to go after
Correct.
both underwriters for the same issue.
That's correct. That's correct. The thing is, I don't know how many of you ever walk out of a closing for your seller with a piece of paper that is a closing protection letter. Do you, Jim? Yeah, you make sure. I haven't been in the trenches in a while, so I'm not totally in tune. But it just seems to me that I don't know whether any seller's lawyers actually get that piece of paper, covering the seller on the CPL. I know they're required to issue it, so it's there whether you have it or not. But obviously a very diligent practitioner if you're saying, hey, where's my CPL before you walk out of the room. Yes, sir.
Joe, you've talked about the control shift between the buyers and the sellers, and one of the things that we're aware of is the fact that some listing agreements, which only the seller is party to, select the title company that will be issuing coverage. Could you include in your discussion the impact of whether a predetermined title company, how that would affect the control between the buyer and the seller?
Well, I don't, that would, theoretically, that would bind the seller who entered into that agreement. But again, the buyer does have the right to choose the title policy that they're paying for. So I would think that even though the seller had obligated himself or herself to use the realtor's title company, the buyer would still have an opportunity to select a different title company for the mortgage policy, unless I'm missing something. Yeah, that would, I mean, that could be problematic for the real estate bar also. Well, let me before I get too far afield, let me just, because I'm going to get into that kind of stuff, but let me move on to the, I mentioned the consequences to the real estate bar, and I've already touched on it, and maybe not much more needs to be said about the loss of transaction control, but there is one piece of federal legislation that's pending that sort of gave us the idea that maybe something is afoot and we can expect a trend. Besides the fact that we had a sort of a spike in these reports last year, and that is this thing called the Mortgage Choice Act. I don't know if anybody's aware of that, but it actually has been. It's actually, and I attached to the handout at the end a summary of it, which was taken from the U.S. Congress website, the Thomas website. In 2015, there was pending in the United States House of Representatives H.R. 685 called the Mortgage Choice Act, and among its provisions was a change in the truth in lending regulations, which allowed mortgage lenders to no longer have to disclose to the borrower revenue that it would receive from an affiliated title company. Okay, so in other words, it's the revenue that was received from an affiliated title company would no longer have to be disclosed or included on the truth in lending. This law actually kind of stalled in 2015, and it became part of the Financial Choice Act last year, which was introduced in Congress as H.R. 5983. And I just updated the other day to find out what's up with that. And that bill seems to have stalled at the end of December. It wasn't moved. But there is now a new Mortgage Choice Act, which was just filed in the House of Representatives on February 16th. That's H.R. 1153, and it's once again called the Mortgage Choice Act. And I looked at the text of it, and it seems to be identical to the text of the 2015 Mortgage Choice Act. And so therefore, and there's no new summary on the website of that, so I included the summary of the 2015 Act. So it should still be accurate, and that's not easy to decipher. I would have given you the text of the bill, except that you can't comprehend it. It just says things like, Section 1A3 will be stricken, the word insurance will be stricken, and in 1BC the word disclosure will be added, and those sorts of things. So if you looked at the text of the bill, it wouldn't make any sense. So the summaries, I'm not sure what I just said made any sense, but the summary is probably the best we can do. But at any rate, what it does is it eliminates the requirement that the mortgage lenders disclose as part of the truth in lending disclosures their interest in an acquired or an affiliated title insurance company. And we've already, and so we've already, and the mortgage lenders, the big mortgage lenders have lobbied for this. And there's a reason that they're lobbying for this. We've already seen a trend toward mortgage lenders and, of course, realtors acquiring interests in title insurance companies. And because they have pretty much first access to the parties in the transaction, at least the buyer, we've already seen mortgage applications where the buyer will check off the box to use the lender's title insurance company. And in situations where the lender is able to offer a discount for title services as part of the deal, of course the buyer is going to say, yes, of course I'll use your title company. And obviously this is at a point in time when the buyer has not had the advice of counsel and isn't aware of all of the other problems and costs associated with a bifurcated transaction. So we were concerned that this bifurcation spike in volume that we've seen last year is going to be part of an ongoing trend, which will continue because of the new regs that govern lenders. And again, it facilitates, if this happens on a large scale, it doesn't take much imagination to understand what happens to your real estate practice when you no longer have the opportunity to order the title. And once the residential real estate practice is gone, it just ain't coming back. Finally, I wanted to mention the harm to consumers, and this should be pretty obvious, but when consumers when they do this, it's sort of predatory, in my opinion, on the part of mortgage lenders, because mortgage lenders, let's face it, don't really have the best interests of your clients at heart. They're in it for the revenue. The only person with whom the consumers have a fiduciary relationship is their lawyer. And if this in this sort of an environment, consumers are deprived of the advice of their own retained counsel on an important contractual issue and of the consequences for their transaction. We found that in cases where transactions have been bifurcated, the discounts that were originally offered to the buyer didn't pan out anyway. They were much less than what were promised to them. And ultimately, consumers suffer when they don't have the benefit of counsel. So some solutions for this, and the one that I want to focus on is our legislative proposal. But as was pointed out, a lot of times this problem can be avoided simply by offering to the borrower, if you're on the sell side of the deal, and you have some control over the pricing on the title services, you can match the discount or approximate the discount that the buyer has been offered from the mortgage lender. And that usually does the trick, especially if they have a lawyer that says, look, you don't want to do this. It's going to be a problem. You got to go to 2 closings. 3 if you're selling, 3 if you're selling. So the language of our legislative proposal is in the handout there, and it's become a lot longer, kind of than what was originally introduced. How am I doing on time, Ralph? Am I?
You got no more than half an hour.
Okay. So when you look at what's in the handout, it's a lot longer than what was originally introduced in the Senate in Illinois, and that's because after we got it going, we shopped it around. We talked to bar groups, we talked to lawyers, we talked to title agencies, we talked to some prominent experts, and frankly, almost everybody is supportive of the concept. There have been a lot of differences over the language that that we needed to haggle out. But basically it's kind of in two parts. There's a public policy statement in Section A, which wasn't there originally, and it just basically acknowledges the harm to consumers because of the unnecessary costs, legal risks, duplication of services, inconvenience, et cetera. And then what the bill says, the meat of the bill says that in any transaction for the sale and purchase of residential real property, the title company that's issuing the owner's policy shall also issue the lender's policy for that transaction unless the buyer and seller agree otherwise. So the buyer and seller always have the right to agree otherwise. Or in the event that the buyer is offered a discount on a mortgage policy as an inducement to bifurcate the transaction, bifurcation can be avoided as long as the seller's title company will match that discount. So the effort was to preserve the economic benefit that is being offered to buyers, because buyers do need to have a choice. I mean, they have a choice. So the effort in that second part was to allow the transaction to remain integral as long as the borrower was receiving the same economic benefit that was offered as an inducement to bifurcate. This, you know, if there's a little competition for the buy side, title services, is a good thing for consumers. You know, I mean, maybe there isn't going to be enough as much revenue in the transaction, but it's a good thing for consumers. And the General Assembly will be looking for the consumer impact on this more than anything, certainly not necessarily the impact on the real estate bar, although as we know, that's very important for consumers also. So urgency is added because of the Mortgage Choice Act, and I think it'll be, once that gets going and the trend becomes sort of solidified, I think it'll be a little too late to get the kind of relief that we're looking for from this. So if you want to, at the end of this, and I'm just about there anyway, I'm going to ask you to be supportive of this, and you can go to the ilga.gov website and just do a search for this bill, and you'll see it. And then there is a spot on the website. There's a link for, I think it's called a GA dashboard, General Assembly dashboard or something, and you can actually click on that and register as a witness in support of the bill, and you can put your comments in and whatnot, and all of that stuff gets read into the record. I'm going to be down in Springfield next week to argue in support of this. It's pending in the Senate Judiciary Committee, and I'm told that the comments that people put on the website will be read into the record. So that's something you can do. Now, let me point out one thing. When you go to the website and you click on the text of the bill, you're still going to see the original text of the bill, at least I think until the end of the day today. After we got this iteration done, we were in conversations with DFI to either get their support or ask them to remain neutral. And just by the way, full disclosure, DFI is opposed to this, and the reason. And the reasons that they gave us, we'd been in conversations and meetings with them for the past maybe 3-4 weeks. The reasons that they gave was they didn't like the language. They didn't like the public policy statement because they said that bifurcation happens downstate all the time without any problem, so they don't see it as a problem. Now, I don't know what counties downstate they're talking about. But I don't think they have a vibrant real estate bar downstate either. So they were opposed to the public policy statement. And just incidentally, I'll tell you that one of our underwriters, WFG, told us they have in one state where this is a prevalent practice, the state of Tennessee, they have a sheet of protocols about who does what. And we were told that even with that, it's a total nightmare there. But in our conversations with DFI, we tweaked the language, we took out the public policy statement, we simplified some of the language in the second part, and when it all came down to it just last week, they said, you know what, we're just going to oppose it. So that sort of delayed our sponsor getting the new iteration of the bill on file. But I was told by our lobbyist yesterday that it should be done today. If it isn't done today, it certainly will be done by next week because the bill's got to move out of committee by next Wednesday. So if you click on it, you're not going to, at least as of right now, you're not going to see the text that's in your handout. You'll see the original simplified text. So if you want, you can just wait until you see the text that I'm pitching right here before you go on and support it. But we would like your support if you're so inclined, and we would also solicit your comments or any input that you might have, whether supportive, whether critical, or otherwise. And you can do that just by emailing our legal department, legal@PNTN. And I'm sure that makes Ellen real happy to hear that that's going to be. But oh, she's okay with it. But then it'll be forwarded to the person in our office that's sort of processing all of the input. One more thing I might add here, and this is a practical solution that you might consider employing right now. A simple clause that I think can be inserted into your attorney review letter. Just to cover the possibility that the buyer might bifurcate. And the language that I've suggested, and obviously your lawyers, you can draft whatever you want, but this is simple and I think unlikely to raise an objection from the other side of the transaction, at least unless bifurcation is contemplated at the beginning. But I would suggest the following. The mortgage and owner's title commitments and policies shall be issued by the same title agency unless otherwise agreed upon in writing by the seller and buyer or their attorneys. I don't know if I put that in the handout, though. Sorry about that. Anyway, I'll repeat it again.
If you send me an email, we can put it on the website.
Yeah, okay, I'll do that. The mortgage and owner's policies shall be issued by the same title agency unless otherwise agreed upon by the seller and buyer or their attorneys. I threw in or their attorneys so that you folks can do it without having to call your clients in. And I know it's difficult to when you're conferring with your clients, it's difficult to sort of explain all of this to a borrower who wants to bifurcate, but you can advise the buyer that in the event that this happens in this transaction, it's going to increase costs. It's going to increase the inconvenience of it. You're going to end up going to 2 closings for 1 transaction, and it's something to be avoided. Your client isn't going to be impressed by an argument that you're going to run me out of business. They don't care about that. But there are some other aside from that that long-term sort of a consequence. There are some immediate consequences in each transaction. The legal problems. The legal problems can be very serious, especially when you have the stress of sitting across the table from somebody who's threatening to, forfeit your earnest money deposit if something doesn't happen. There's a lot of talk about e-closings, and supposedly it's an imminent sort of thing. Although I don't know, I maybe I'm too old to, really imagine that. But it seems like it's been kind of talked about a lot. I don't see anything really happening. Maybe you guys do. But I suppose that once we get to that point, if we ever do, a lot of the logistical problems that I'm talking about will be cured by that. But it certainly won't help the larger issues that I talked about. So I think that's about all I have to say. I don't know if there are any questions or if anybody has anything to discuss.
Of course there are questions.
I appreciate the trepidation, but I would be more aggressive than saying it's up to the parties or the attorneys. I would be putting in my attorney approval rider, if this gets bifurcated, the charge from the buyer will be $1,000, and if this is going to be for the cost to my client for all the inconvenience that he's going to have, and if they don't like that. And I would also insist that the $1,000 be put on the HUD, well, not the HUD, the closing disclosure, and make sure the lender has to see that as a charge to his buyer for this transaction. And full disclosure, guys.
I have no problem with that whatsoever, because one of the problems that lawyers have had historically is that we don't really charge enough for our legal fees. We don't
Amen.
charge for all the times we touch that file. We don't charge. We're imparting way more value to our client than what we're getting paid for, and we all know all of the reasons for it. I mean, our fees are sort of suppressed not only by competition among us, but realtors who quote fees for us, and there are all kinds of factors involved. But you're absolutely right. $1,000, that probably is I don't know what you're charging for real estate deals, but I'm wondering if $1,000 will cover it in a transaction where it really gets into the nitty gritty. We've had some feedback that, and from the DFI also, with regard to the concept that what we're doing is really restricting consumer choice. And I think that that's sort of an illusion. That argument is sort of illusory, because there's more than one consumer in the transaction, okay? The seller is a consumer also. And if the buyer is offered some benefit, which benefits the buyer, but the consequence is to make life miserable, increase costs for the seller, where's the choice on that side? So what we've done here is to try and preserve the benefit that the borrower would get while allowing the transaction to stay together.
I have a question. I'm wondering if you've had any thoughts on this, because you mentioned the possibility of having something that would be adjusted by the benefit offered to the buyer. And it's driven by the dollars. The clients aren't going to be concerned about whether you're driven out of business. They're worried about whether they're going to be able to save some money on the transaction. Right. So when given the opportunity to go for the bifurcation and have a discounted kind of a premium for that policy, they're going to go for that every time, even if in time-honored tradition, the bold print gives and the fine print taketh away, and the fine print includes an arbitration clause,
right.
And there's a substantial discount being offered. And ultimately, when you see how it plays out, it really wasn't that great. But at the time that the transaction is being developed and is coming together, what's the seller going to do with the title insurance company involved if the discount that's being offered is so great that you really can't match it?
Yeah, that's a problem, and it's not too hard to imagine that happening, because some title companies we know can operate at low or negative margins for a certain period of time. I don't know what the answer to that is, though, Ralph, because you can't. I don't think that you can simply make it illegal. I think that you always, and I think that the general, even if you could, I don't think that the General Assembly would be amenable to simply telling consumers that if a buyer has this great deal available, you can't take it. So I don't know what the answer to that is.
Well, let me just suggest that in considering it, it would be helpful if, as a bar association, we had input from people to run into this situation. And if you had a situation where the borrower was offered a, 50% discount, and it turns out to be 4% after everything is all said
Sure.
and done, the number of horror stories that we have available can help us in negotiating the transaction and maybe get more acceptance of the kind of proposal that we're going to have here about saying, here's what's going to cost my seller if we have to do the 2 closings, here's my charge for the bifurcation, and here's the reason, here's the horror stories that can result.
Yeah, I think that that's absolutely correct. And anybody who has a horror story, if you want to log on to ilga.gov and throw that horror story in there, all of that sort of anecdotal kind of stuff is important to support the public policy statement that we're asking them to consider. So we're saying that the law of the state of Illinois is acknowledging the harm and the inconvenience and the legal issues, et cetera, et cetera. It's nice to have in the record some anecdotal support for that public policy statement.
And I'm going to selfishly go beyond that and say, if you don't mind, in addition to going there, if you have the horror story, copy us at info@irela.org. Ray.
Ralph, I got a question. Once the seller's title insurance company decides that they're going to accept the risk in the transaction and issue an owner's title policy, notwithstanding that they had to exercise underwriting judgment on some possible clause on title. What is wrong with that title company being asked by the lender's title company to issue a hold harmless to the lender's title company once they have decided to issue the owner's policy and assume whatever risk is involved?
Well, I think that from the title underwriter's point of view, why would they undertake to extend their risk on a policy that they're not obligated on already? I mean, we used hold.
Because, if I'm not mistaken, their contract, their owner's title policy with their then insured seller is going to protect the seller against any claim that's made by that new lender against the seller's title.
Against the seller or the new owner?
The new owner. So aren't they in a roundabout way going to be involved in any such risk?
Well, in the event of a claim, yeah, they would be involved, but why should they undertake any obligation to the mortgage lender? I mean, it may be that if the claim is paid, they'll end up paying the mortgage lender.
But we're asking title companies all the time, once the owner's title policy is issued, where we're representing a seller to issue a hold harmless to the new title company.
But isn't that's typically a situation where that's a situation where you've got an owner who's covered by an owner's policy who's now selling to a third party, and an issue comes up, and you go back to their insurer and say, we need a hold harmless letter to cover this thing that you might have missed or whatever. They're willing to do that because they're obligated already.
But they're already obligated anyway once they say they're going to issue the owner's policy. Am I correct?
They're obligated to the owner, to the new owner, the insured only. They're only obligated to the insured. Why would they obligate themselves to another insured when they have no policy on that insured?
The same way they issue hold harmlesses between each other.
Well, I don't see it myself. I don't know what.
I haven't thought it completely through.
Yeah.
But I think that is a viable situation.
Well, Ellen is the smart one in our office. Can you hand the mic to her? She's got.
Well, I used to work in a claims department, and the things that I would worry about are cost of defense to another defendant that you're not already obligated to defend, and also just the calculations of how much is owed when there's partial risk, or I guess even when there's full risk. You'd end up paying more because the lender would have different costs that they could prove up. So the risk would be there. And the reason it's different from the hold harmless situation is because when we're giving hold harmlesses back and forth or using that inner title company hold harmless agreement, it's because people are owed title insurance under continuation coverage, having to do with the warranties under a warranty deed. So you're owed prior, everybody who goes back in time somehow until the risks, that latent defect that caused the problem started, everybody who gave a warranty deed is owed some continuation coverage, which would not be the same with a lender on a loan policy.
Well, in the first place, when the lender goes through the underwriting process, probably the risk to the lender after that.
Well, the lender goes through the underwriting process, yes?
Yeah, after that underwriting process, the risk has probably been weighed and very minimal. And consequently, that's why they agree to do it in the first place. So what's the difference if once they make the commitment to issue the owner's title policy, they insure the risk on the new buyer, and therefore they should give a hold harmless to the lender. It doesn't make any sense to me why they wouldn't do it.
Well, I think that's assuming the risk is not a risk. A lot of, well, that's sometimes the case, and sometimes they're proven very wrong.
What about, Joe, the coordinating between the two closings? I mean, you know, the seller's title insurance company may not want to issue the policy until they know that the loan, you know, the money's come in for the loan and that the prior mortgage has been paid off successfully. And how is that coverage going to be coordinated? I mean, maybe they're going to say, we're not going to issue the policy unless and until we have proof that the other part of this, you know, the shoe has dropped and it's all been resolved. What goes on in your experience?
Yeah, well, that is a situation that we had, and in one case, we talked the sellers. In that one case I mentioned, we didn't, but we suggested to our member attorney, who then talked them down from requiring a copy of the recorded release of the paid-off mortgage. And ultimately, they accepted, I think, a photocopy of the check or something like that. But yeah, that's an issue. That's just one of the issues. I mean, if you were insuring, if you were going to be on the hook for the owner's policy, would you undertake gap coverage, not having any control over that risk whatsoever? Would you waive a mortgage at the table on the promise that it's going to be paid later in the day? Yeah, it's a problem. There are a lot of phone calls going back and forth.
I am not familiar with any lenders, and maybe I just need information that are getting into the mortgage or the title business. I am familiar with a lot of realtors pushing their title companies. So who are the lenders that are wanting to get into? I just haven't seen it.
Yeah,
Or it's just
I can give you the names of the ones that we experience. In a couple of cases, and I honestly don't remember them now. I'm not, I'm not sure I want to name names anyway. But in three of the transactions that we had last time, there were in common the realtor, the lender, and the buyer's attorney. And so I spoke with the buyer's attorney about it because it was like the third time that we had the same sort of situation. And the buyer's attorney told me, look, I'm against this myself, but this is what my clients are insisting on. And I tried to find out, is this being something that's instituted by the broker or the lender? And the broker, I didn't speak with the realtor's office myself, but the realtor denied that it was that they had an interest in the title company. By the process of elimination, I'm assuming it was that. But again, we do know that. I wish I could give you that information. We do know it's been reported, let's say, in industry publications that lenders are beginning to take steps to acquire interest in title companies so that they can handle the title work also. Sort of one-stop shopping kind of thing.
When you do a bifurcated closing, are there two closing fees? Is there one for the imposed by the
The
insurer with the sellers and then also the buyers? So wouldn't that
Yes, there-
automatically increase the cost?
Yeah, it does automatically increase the cost, but the closing, the escrow fee that you normally see would be charged by the mortgage policy, and I believe what we saw on the seller side was like a room fee or something like that.
Okay. So you could also suggest that if they are going to bifurcate, that buyer and seller have to split that cost, or
Well,
that's the cost of the buyer because now you've
Sure.
got an additional fee.
Sure, if the buyer's self-interest, if the buyer's self-interests cause the buyer to make a decision that impacts the seller adversely economically, there should be some accommodation.
Yeah, and I'm not sure that I'd be so generous as to just suggest splitting that. If the buyer's decision and the buyer's self-interest increases the cost of my seller, I might take the position that, hey, that's part of the 1,000, or that's
Yeah.
any additional increase on the seller, because you don't have to do this.
Right.
It's going to be the buyer's responsibility.
Right. Well, the thing is, though, the bargaining leverage on the seller side isn't that great because you can't say they don't have to do that. We don't have to do this because the buyer does have the right to choose the title company that they're buying the title from.
But not the right to unilaterally increase the costs on the seller.
Well, I guess that's a question that, if that's a consequence of them exercising their right under Section 18.1, I guess that would be a litigated. It's a problem with 18.1. Well, 18.1 sort of existed in other forms anyway. But yeah, you're right. They have the right.
I think that goes along, though, with what I said earlier, and that is also to be put into your client agreement so that they're warned and prepped so that you can't get blamed. The deal fell through because they rejected your attorney approval rider because of what you put in there.
Yeah.
And so I think you put that in there just to protect yourself as well as the seller to understand the situation before it happens.
I agree with you, and I've always sort of taken a harder line, so to speak, with clients. I mean, I let them know what the fees are. I let them know what we were willing to tolerate, not necessarily with bifurcation, but I was always very upfront with my clients about what they can expect to pay. I always sort of wanted to inoculate them at the beginning. Maybe I sounded like a lot of bad news when they first came in to talk to me, but I always wanted to sort of inoculate them at the beginning of some things that could happen. If you handle 500 deals in a year, you don't know which one's going to have this problem or that problem, but one of them's going to have it. So, John, do you have?
Well, I just like to interrupt for a second and
Sure.
say that this has been very interesting. Joe is going to be nice enough to repeat this program at the Chicago Bar Association tomorrow at 12:15 down in South Plymouth Court. If any of your associates you think might be interested in hearing this, I'm the chair. Please tell them to come as my guest. So I just wanted to get that plug in. Thank you. Sorry to interrupt.
Thanks.
No, thank you for mentioning that. I was going to mention that, John, and then you'll have a chance to see Joseph take full credit for Phil Stein's idea.
Yeah, exactly.
Is there any time limit as to when bifurcation requests can be made, or maybe there should be? Like, well, if you want to bifurcate, you got to do it within the first 10 days of the deal. After that, it's too late. Is there any thought about that as a defense?
We did contemplate that. The problem with that is we thought about a cooling off period, that sort of thing. The problem is, number one, in the first 10 days, buyers sometimes don't go to see their lawyer for more than 10 days after they sign their loan application. It would be hard to come up with something that would be effective. And then the other part of it that sort of complicates things is any time period that you have would have to be triggered in some way, for example, by a notice. And we didn't want to get into a situation where buyer has to send a notice to the seller, then the seller's got 10 days. And so the only thing that we did put in the bill was that the seller has, whenever the request for bifurcation or demand for bifurcation is made, the seller has all the way up until the time of the closing of the transaction to match the economic inducement. We thought that would, yeah.
Let me just make a comment about, the insertion of that kind of language in the attorney engagement letter, in addition to the writer. I think it's critical to cover this in your engagement letter. And I wouldn't be so apologetic. I mean, I would be taking the position that I'm the only individual in this transaction who has a fiduciary responsibility to you. Other entities, realtors, lenders may promise the moon and the stars, and guess what? You can't count on them coming through. I've got a fiduciary responsibility. Here's what I have to have you understand as, part of that transaction.
Yeah, agreed.
If I could follow up on that, obviously in my engagement agreement with the seller, I informed them that I may choose one of several title companies depending on my criteria for why I would choose those title companies, so they know in advance, and that I may be compensated for doing so.
Sure.
And that's just sort of a summation. But I'm going to go back to the question I asked before about when a listing agreement is signed and the seller arguably chooses a title company in the listing agreement. I assume that if this amendment is put in place, that even 6 months or during the term of the entire listing agreement, the seller's attorney, because of his relationship with his client, could choose, along with the buyer, a title company that's not in the listing agreement, either for the purpose of bifurcating or just that it's in the economic best interest of both parties to go with a title company that was not the one designated in the listing agreement.
Yeah, I think that's a good question. I don't know how binding that selection in the listing agreement would be.
Let me just jump in on that,
Yeah.
because it reminds me of litigation that we were involved in where we were arguing UPL issues, and we got a result from a McHenry County judge. One of the things that has happened with IRELA over the years, and it was, again, I go back to the founding of this thing by John O'Brien back in '97 or whatever. At that time, people were saying that the writing's on the wall. Attorney's going to be out of the transactional area in this, within 5 years. Well, here we are. We're still kicking, and I like to think it's at least in part due to the efforts of IRELA. In that litigation, we had a listing agreement where the seller was signing, without, of course, reading the fine print, saying that they were betrothed to this title insurance company that was a captive title insurance company. The settlement agreement that was reached, and we have it available, and I can share it with you. Now, obviously, it's not something that's binding statewide or anything, but the rationale was where you can show that there is an economic benefit or that there's a decision made by an attorney that for legal reasons it's better to use the title insurance company selected by the attorney, and that reasoning is not solely because there's an economic driver here that there's going to be money made by the seller. You could have termination of that listing agreement requirement for that title insurance company selection within 5 business days of the signing of that listing agreement, and you had another window of 5 business days after the acceptance date of any subsequent contract to do the same thing. That gave the parties involved in that situation a little bit of leverage.
Yeah. Well, there's sort of an analogous provision in the Illinois Administrative Code that was passed a few years after 18.1 went in the title insurance section. I think it's 50 Illinois Administrative Code 8100 something, but there's a section down there for consumer protection, and that specifically gives a buyer the right to cancel any title order that their lender made all the way up until the time of closing. Now, that's sort of limited to borrowers and lenders. I suppose the reasoning behind it could be extended, just as you say. So there's sort of an analogy there.
Sure. We only have Joe for another 45 minutes, so if you have any questions, now is the time to raise them. We thank you for your participation.
Thank you.